Okay, so thanks for everyone for joining us today for our session. This is the latest in our series of webinars. A few of you have been to quite a few of them. Hopefully you're finding them useful. I've sort of what we're calling everything you wanted to know about a particular subject. And today our subject is unfair dismissal. So Julie and I will be taking you through, I suppose, some frequently asked questions about this area, a few practical tips, a few suggestions, a few things to be aware of at quite a high level. And obviously if anyone has any questions and they do want to ask any specific questions, feel free to jump in, ask away. We do like it to be interactive, as many of you will know, and there'll be time at the end as well for questions on what we've talked about, or anything else at all for that matter as well. So please do just jump in whenever you want, and we'll have a chat through. Okay, so without further ado, let's get started with our topic today. So yeah, as I say, we're talking about unfair dismissal, and as we know, there can often be times between ourselves as employers and our employees when that relationship it needs to be ended. Something's happened and we need to bring that to an end. Now, if it's us as the employer doing that, then that's known in law as a dismissal. Now, obviously, getting this process right can make what can otherwise be quite a difficult, stressful task quite a bit easier, and also minimize the commercial and financial risks of facing what would be an unfair dismissal claim in the employment tribunal. So that's what we're going to be covering today, some questions on that topic. And the first question, obviously, and it's useful just to remind ourselves, is what exactly is an unfair dismissal? In this context, an unfair dismissal is something which occurs when an employer dismisses one of its employees, and it strictly only applies to employees, not workers or self-employed people. But when an employee is dismissed for an unfair reason, or should I say for not one of the potentially fair reasons that we have listed in statute, and or if they do not follow the correct procedures for the dismissal or for that particular type of dismissal. So in a nutshell, how can an employer avoid dismissing an employee unfairly? Well, they do that by dismissing for one of the potentially fair reasons. They ensure that that decision to dismiss was in the circumstances a reasonable decision, and they follow a fair process or a fair procedure in reaching that decision in order to demonstrate that it's been fair and a reasonable decision. So I mentioned there a couple of times about the fair reasons for dismissal. These are set out in the Employment Rights Act, and they are listed, and they're all things that we'd be familiar with, some perhaps more than others, but a dismissal will only be fair if it's for one of these specific reasons. So they are conduct, or put another way, misconduct, capability or qualifications for the job. Now that can include an employee's performance, or it can also include their health or their ill health, meaning that they're not capable of carrying out the requirements of their job. Another potentially fair reason is redundancy. I'll be familiar with that. Another potentially fair reason is illegality. So where it becomes illegal for an employer to employ an employee, that may be a fair basis for dismissing somebody. And then we have what we call a bit of a catch-all reason. So it's what we call some other substantial reason, where that's sufficient to justify a dismissal. And there are lots of different examples of that. One common one is where a customer, for example, has demanded the removal of an employee and there are no other alternatives. It may be that an employer may have no other option than to dismiss that employee. So that's within that category of some other substantial reason, potentially, with all the other requirements of a fair dismissal as well. Now, in our discussion today, in our talk about unfair dismissal, we will be primarily doing so within the context of a conduct dismissal. I think that's likely to be the kind of dismissal that most of us that are in this call today will be the most familiar with, will have the most experience dealing with. So we're going to be looking at unfair dismissal within that particular context, whilst touching on a few of the other areas as well. So I'm now going to pass over to Julie to talk us through how employers can ensure, or how they can know that their dismissal of an employee is reasonable.
Thanks, Gareth. So as Gareth mentioned, first of all, you come to decide what the reason for the dismissal is. And then the second aspect of the process is essentially is to determine that your decision is reasonable. So is it reasonable to dismiss the employee for misconduct, for instance? So the test really about what is reasonable is if something is, and this is a phrase I'm sure you'll all be familiar with, if something is within the range of reasonable responses open to an employer in similar circumstances. So this means, and this allows an employer various options in a particular situation. So various actions would all be considered fair as long as it's within this reasonable range. So the decision that the employer takes will therefore be considered to be reasonable, provided it's not viewed as one that no reasonable employer would have taken if they had been in the employer's shoes. So in an unfair dismissal claim, quite often what will be argued is that the decision was unreasonable, and it's a decision that no reasonable employer would have taken. But an important point to note here is that it's not for the employment tribunal to substitute its own view for that of the employer. So they couldn't say, well, we wouldn't have dismissed for misconduct. That seems a bit harsh in those circumstances. That's not the test. The test is if an employer in similar circumstances would have taken such a decision. So it would only be unreasonable if no reasonable employer would have decided to dismiss. And that's essentially quite a high test. It gives an employer plenty of leeway to take action that's appropriate for their business or organisation, because the employment tribunal would look at the organisation, the business. You know, if an organisation has 3 members of staff and someone is persistently late, then it may be a dismissal. Appropriate to dismiss and reasonable to dismiss. But if someone has 400 staff and someone is persistently late, the employer may be expected to take quite a few more steps before dismissal would become reasonable. So essentially, as I say, it's not quite how long is a piece of string, but there is a lot of latitude within that decision-making process. And the reasonableness factor applies when you're considering the substantive decision, which is the why. Why did you dismiss that person? Was it reasonable to determine that they had been guilty of misconduct? And also the procedural steps. So when would that apply? For instance, if you delayed in holding an appeal hearing, but the reason you did it is because you were trying to investigate something and one of the employees was on holiday. So was it reasonable in those circumstances to delay the appeal hearing to allow you to get that piece of information? And so the test applies to both key aspects of a dismissal. So that then brings me on to the basic procedure that an employer should follow to ensure fairness. I know it's something that a lot of you will be familiar with. It's probably your bread and butter, actually. I remember once being told that the only instant thing in a workplace should be the coffee. So very rarely can an employee's actions allow you to dismiss them on the spot without following any sort of procedure. So even in the cases of a violent or threatening employee, removing them from the premises is as far as the immediate reaction should go, with a formal process or a truncated process to then follow. So I'm sure most of you will be familiar with the basic procedure, so we'll just go over it very briefly. So you're faced with an employee who you know, there's an allegation that there's something wrong, or that they're ill, or that they're not very good. And it will also apply in a redundancy situation, but that's a very specific procedure, but you know, it has the same bones effectively. So you would always conduct a reasonable investigation into the incident and or the allegations against the employee. You have to have a full picture about what the problem is before you move forward. You then have to advise the employee that you're commencing a procedure that may culminate in their dismissal. and explain the reasons for this. And that should obviously be done usually verbally and then certainly in writing. And then you would invite the employee in writing to attend a meeting, and that is the employee's opportunity to tell their side of the story. So it's not, Perry Mason full-on court case, but there are, principles of natural justice. You say what you think the problem is, and then they get to challenge that or explain it or provide mitigating circumstances. And at that meeting, you must allow the employee to be accompanied by a trade union representative or a colleague. That's the law. Sometimes people will ask to bring their mum, or I've even had clients who have wanted to bring a lawyer, and that's then a decision for the employer to make. They are not obliged. And sometimes it might be conducive to the meeting to allow it, but it may not, certainly not a lawyer, I would imagine. And then you have to consider all the relevant information and make a reasonable decision. And this is where investigation reports and more written evidence of your decision-making process. This is where this really comes in useful, because if the dismissal is challenged, you want, it might be kind of 18 months, 2 years that you're having to explain why you made the decision. So it's very important to have contemporaneous notes and your justifications as to why you have come to that conclusion. And then, of course, you must inform the employee of the decision in writing, and then you must allow the employee the right of appeal against the dismissal. So it's common, as an aside here, it's common for employers to set out the detail of their disciplinary procedure in a staff or an employee handbook. And if your organisation has one, which most do, it should be carefully followed, or you should be able to justify any departure from your procedure, for instance, if the employee is not being cooperative. I've seen employers suffer in legal proceedings for following a procedure rather than the one that they've set down, and this is especially so in relation to any time limits that you have put in writing. And that's why usually in handbooks we would try and say this is the time limit, or such other time as is reasonable, to give yourself a bit of flexibility. So again, you want to be able to give an appeal, hold an appeal hearing within the time limit that you've set down in your handbook, if you've done that. And in fact, there was a case recently, I noticed, Tijani against House of Commons. There was a cleaner in the House of Commons consistently late. She was dismissed during a live final written warning. But one of the lines of attack from the employee was that the disciplinary policy hadn't been referred to during the dismissal and certainly wasn't produced at the hearing. And so the tribunal had to come to a conclusion that persistent lateness, was generally held to be misconduct. And it would all have been so much easier if the disciplinary process, which had been written obviously by the House of Commons, had been referred to throughout the process. So that's just something to say about, if you have a written process, follow it. And I think that leads us nicely into another of the tests that an employment tribunal will also consider. And Gareth is going to take you through that.
Thanks, Julie. Yeah, just quickly on that I've mentioned in terms of written procedures, whether it's in your handbook or otherwise. Another thing that's relevant to those kinds of things, for, as I say, we're talking in the context of conduct dismissals, you're always going to want to be conscious of the ACAS code of practice on disciplinary and grievances. Now that applies, as it says on the tin, really, it applies to those kind of procedures. So it doesn't necessarily apply to, or it doesn't apply to redundancies and performance processes and things like that. But for a potential conduct dismissal, there is guidance published by ACAS. Now that's not strictly the law, it's not a legal requirement to follow it as such, but it's a really strong indicator of what a fair procedure must look like. And it's become so commonplace that any employer that departs from that is going to really struggle to to demonstrate fairness at that minimum level. As Julie was saying, your handbook might go further or might include more detail, which also needs to be followed. The crucial thing, whilst it's not legal or a legal requirement to follow it in terms of the ACAS code, if you don't, and it's unreasonable to have not done so, the tribunal can uplift any compensation that's awarded to an employee who successfully demonstrates they were unfairly dismissed, and that uplift can be up to 25%. So the compensation is calculated, and then they uplift it by 25% to say, well, you know, the ACAS code's there, and you've not even followed it. So it is a really important document. Doesn't necessarily include anything that would surprise anyone on this call or anything different from what we've talked about, but it is just another example of how employers are guided to behave fairly when it comes to dismissing employees. And the other test that Julie was just referring to that I wanted to mention, you may have heard this said when it comes to misconduct dismissals. You might hear lawyers talk about the virtual test. Now, that's a test that comes from an old employment tribunal case of the same name, which basically established that there's a basic level of fairness required in reaching a decision to dismiss someone for misconduct. And essentially that requires three things. Firstly, it requires that the employer has a genuine belief that the employee is guilty of the misconduct allegation. Secondly, that the belief in the employee's guilt is formed on the basis of reasonable grounds. And thirdly, that the employer has carried out a reasonable investigation in order to reach that belief. Now, I mention that because it's quite a useful test to bear in mind when it comes to proving allegations of misconduct, because it reminds the employer that the standard of investigation and proof is not at the level that it would be, for example, in a criminal investigation. And you often see this with misconduct allegations where an employee may think that in the absence of, undeniable concrete proof, that they can't be touched by their employer, and that's just not the case. The employer is not needed to approach this, as Julie mentioned before, Perry Mason, prosecution style, proving beyond all reasonable doubt. It's nothing like that standard. It's about having a genuine belief and having a reasonable basis on which to reach that decision. What that actually allows, without getting too off track, is an employer could be wrong, but they could have genuinely believe that they were right and have a reasonable basis for that belief. And it's always useful to remind yourself of that if you're in the shoe, if you're dealing with a disciplinary process, trying to decide whether to uphold it. You think there's evidence, but you haven't got a smoking gun, for example, and to carry on that Perry Mason example, remind yourself that is not what the requirement is. It's all about going back to that test. Do I genuinely believe this employee has done as alleged? Is that based on reasonable grounds, and have we investigated it reasonably to reach that conclusion? If the answer is yes to all three of those, then a misconduct dismissal, as long as you follow the correct procedures, it is likely to be fair. Just a couple of other little things to mention as well on the procedures. Julie touched on this in terms of an appeal. An appeal is always going to be a useful opportunity, not only to provide the employer another chance to kind of lay out the rationale for the decision to dismiss, but it can also be very helpful in curing any problems or defects or flaws in the procedure that have come up earlier. So if for example, part of an employee's appeal is to say that a piece of evidence was overlooked, or it wasn't taken into account, or a witness wasn't spoken to that would have given a clearer picture, well, at the appeal stage, that will give the employer a chance to go and cure that defect, so that by the time the appeal is concluded, they could have repaired that and get it more on a fair track, and make the decision a fair one. Now, appeals can be held in lots of different ways. They can be complete rehearings, so we're going to approach this completely again with a fresh pair of eyes, looking at the whole thing in the round, or it can just focus on very specific points which were raised by the individual. So if the employee says that they believe their dismissal was unfair for 3 specific reasons, you assess those 3 reasons. If you're happy that they don't apply, then the original decision stands. So there's lots of different ways to go with that, and the circumstances will dictate which is the best one. the crucial point there really is that there should always be an appeal for the reasons we've mentioned. Now, I'll just briefly touch on a couple of the other types of processes. As I said earlier, we're focusing really on primarily on a conduct-related dismissal in our examples today. But it's useful to just remind ourselves that the other types of dismissal that we mentioned earlier, so for example, performance-related, for example, redundancy, each of those involves different requirements to ensure a fair process. So just by way of really quick example, a redundancy process, a fair process there would require, among other things, that employees are adequately warned and consulted with, and that they've been fairly selected for redundancy, for example, through objective and measurable scoring criteria. And it'll also require the consideration of alternatives to redundancy. Another example, a capability process in relation to poor performance, that would require usually a series of improvement notices, essentially warnings, and a chance for the employee to have a reasonable period within which to improve. And similarly, if we looked at a capability process in relation to ill health, then an employer is going to want to go through a process of considering all the medical information that's available to it to determine what the employee is capable of doing and their likelihood of being able to return to their role, as well as the consideration of alternatives if they're not able to do so. I know in some of our previous sessions, which many of you have attended, we've kind of gone deeper into those kind of issues with redundancy and things like that, but it's just a reminder that the things we're talking about today primarily are to do with conduct, but there'll always be specific processes to be followed in relation to different types of dismissal. I'm just going to pass back to Julie now, who's going to take us through a few more common questions we get asked around unfair dismissal.
Thank you. Thanks. So one of the questions that we're asked is, what is the length of service necessary before an employee can make an unfair dismissal claim? It's not from day one, as I'm sure most of you know. The employee must have been employed by the employer for and if it's less than 2 years, don't forget to include the employee's period of notice in assessing the length of service. If not, a claim for unfair dismissal can't actually be made unless there are one of the statutory exceptions for describing what's called an automatic unfair dismissal. For instance, the employee was dismissed after her first month when the employer discovered that she was pregnant. So that would be an automatic unfair dismissal where she would be allowed to claim immediately. Length of service in this context is actually a bit of a political football. When I first started my career, Tony Blair's Labour government changed the qualifying period from 2 years to 1 year, not to give any hints as to how long I've been doing this. The Conservative government, as you know, have since changed it back to 2 years. And I've heard pretty sure in the Labour Party conference that they're talking about employment rights from day one. And I think that there is an argument being made by them that you should be able to claim unfair dismissal from the very first day of employment. We haven't heard more detail about that, but at the moment it is 2 years. In any event, obviously, our advice is to always closely manage employees, especially in terms of conduct and job performance, with one eye being kept on this kind of 2-year market, because a dismissal before this period is obviously much less risky because they simply can't claim unfair dismissal. But what they can claim from day one is discrimination, some form of discrimination. So employees still have some protection, which is why we always advise, even before the 2-year marker, to follow some sort of procedure. You might be less strict with it, but to have followed a procedure helps to defend any assertion or any accusation that the dismissal was motivated by some sort of discriminatory motive. And therefore you're able to kind of push against that and rebut that, because you say, no, look, we followed a process, we investigated, it was clear there was misconduct or performance issues, and that was the reason that we dismissed.
That's why we really advocate as well using I know a lot of people on this call will do so, but effectively using the probationary periods really effectively. So using that as an opportunity to assess employees and manage them fairly in a context where they're likely to be expecting you know, there to be some kind of review during that period. It's all very clear when they take on the role. You can use that period and even extend it if your contracts allow, in order to really ensure that any decisions, whether it's, you know, someone's got a poor performance level or poor attitude to the role that's causing problems, that can really be dealt with following a much simpler probationary review process and be tackled way in advance of that 2-year mark coming around. So one of the best tools you can use is that probationary period, certainly in my view.
Yep. And I think you're going to touch on unfair constructive dismissal, Gareth.
Yeah, absolutely. So another thing that you might hear people talking about is constructive dismissal, which does fall under the same umbrella effectively as unfair dismissal, but essentially this occurs when the employee resigns rather than that the employer has dismissed them. Now, it's usually where the employee resigns, citing some sort of perceived breach of contract by their employer. And there are essentially 3 requirements for a constructive dismissal. It can be quite a complicated area, quite complicated cases if they come up, but in a nutshell, the 3 sort of essential requirements are that firstly, that there's an actual or an anticipated fundamental breach of contract by the employer. So that's something that's particularly serious. It goes to the very heart of the contract and the employment relationship, so as to be sufficiently serious to justify resignation. The employee must actually resign in response to that breach rather than for some other reason. So, for example, not because I don't like this job, I found a better one, so I've resigned. It must be that they've resigned specifically in response to the alleged fundamental breach. And the employer must otherwise not delay too long in terminating the contract in response to the breach. Otherwise, if there's too much of a delay, they'll be regarded as what we call having affirmed the contract, or basically accepted the breach or forgiven it in effect. So it's those 3 elements. There's a breach, they resign in response to it, and they do it relatively quickly in response. Now, the important thing to note here is that unreasonable behaviour by the employer will not in and of itself be enough to allow an employee to resign and claim constructive dismissal. It needs to be something particularly serious so as to amount to a fundamental breach of the employment contract. Now, often a big clue to this type of thing is the employer, of when the employer might be gearing up to make this kind of argument or take this type of action, is when they undertake in repeated or protracted grievances and complaints. And it's just another reason why grievances need to be dealt with carefully and reasonably to avoid any accusation of unreasonable behaviour by the employer, but also to try and nip any potential constructive dismissal claim in the bud. Now, one of the ways that you'll often, or one of the most common ways you'll find that constructive dismissal is alleged, is in relation to not necessarily a specific explicit clause in the contract, but more in relation to what's known as an implied term in the contract. And typically this is an implied term of mutual trust and confidence between the employee and the employer that basically underpins the employment relationship. Now, most constructive dismissal claims will be based on an employee saying that there isn't necessarily a specific written clause that's been breached. So I've been paid properly. I've been doing my, I've been receiving what the employer says I'll receive under the contract, but I've been subjected to bullying or discrimination or something that means that actually this level of trust and confidence that I'm entitled to expect has been breached. That can be treated as a breach of contract, and now I'm going to bring a constructive unfair dismissal claim. There's obviously a lot more we could say about constructive dismissal. We're not going to go into much more detail about it here, because it could be an entire webinar of its own, really. But it was just to flag that issue up in terms of the context of an unfair dismissal. You've also got the concept of constructive dismissal to bear in mind as well. Now, I'll just pass back to Julie for a few more questions around the kind of common ones we get asked about an unfair dismissal claim.
Thanks, guys. So another time limit that applies is the time limit that the employee has for lodging an unfair dismissal claim. So once they have secured their 2 years service, they are entitled to raise a claim, and they must submit a claim to an employment tribunal within 3 months. It's actually 3 months less 1 day from the effective date of termination, so the date that they left the job, and if it's with immediate effect or upon the expiry of a period of notice. And so if you have jumped through all the hoops and unfortunately the employee has been successful a fair dismissal claim, they're entitled to compensation. And an employment tribunal can make various orders, including that you give the employee their old job back, but the most common one is financial compensation. And it comprises 2 elements: a basic award, which is akin to a redundancy payment, and a compensatory award. And the amount of the compensatory award is limited now to 1 year's salary, and that 1 year's salary limit is itself capped, and that's currently at £93,878. So it can be a very expensive mistake to obviously be awarded to lose an unfair dismissal claim and then have to pay out that amount of compensation. And when you are arguing about compensation, there are still a few tools in the tool belt that an employer can argue back to help to kind of to reduce any amount of compensation. The first one is called a Polke reduction, and that's an argument by the employer that the employee would have been dismissed anyway, and therefore compensation should be reduced to the length of time that a fair procedure would have taken. So it would apply where you have made a mess of the procedure effectively, and you would argue, well, they definitely were fighting in the workplace, and so we would have dismissed them, and a proper process would have taken 4 weeks, say, being generous, and therefore their compensation should be limited to that because it only took us 10 days, or we told them to leave immediately that day. And so that's one argument that you can advance if you are having to pay compensation. Another argument is contributory fault, and that's an argument by the employer that the employee contributed to the dismissal through their actions. They have been guilty of some blameworthy conduct, and therefore compensation should be reduced accordingly. So where the tribunal concludes that the dismissal was caused or contributed to by an action by the employee, the compensatory award can be reduced by a proportion. And we would normally always argue, oh, that's 100%, it should be reduced by 100%, but that's very rare. So normally you will find maybe a 50 or 60% reduction in the amount of compensation because the employee was blameworthy in some way, and therefore contributed seriously to their dismissal. And that's really it, a whistle-stop tour of unfair dismissal. Although there was one other point that Gareth I wanted to bring to your attention, that a piece of legislation that was published yesterday, and it's called the Retained EU Law Bill. Revocation and reform sounds fairly innocuous, but it's a Brexit bill basically. And what the government are saying is that on the 31st of December 2023, all EU law that is currently relied upon within the UK justice system in employment will vanish. I don't think it's actually just limited to employment, but we're obviously talking about employment, unless the government takes active steps to reinstate it in some UK legislation. So that might not sound particularly dramatic until you realise that the working time regulations are largely an EU institution, 48-hour working week, paid annual holiday, and of course the lovely 2-pay laws. So the fact that an employee's employment is protected when they transfer, their terms and conditions travel with them to the new employer, protections for part-time and fixed-term workers. All of these are EU inventions essentially, and may come under fire depending on who the hell's in charge in December 2023, who knows. And essentially it's just something to kind of keep on the radar, because I don't know, there's a few other things going on just now, so this one kind of slipped under the radar. So
it did sneak
we'll
in a little bit, didn't it?
Yeah, we'll update you on it as we know more, but it's something to keep an eye on in the horizon.
We'll be doing a little blog about, well, just summarising what Julie said there as well, just sort of a bit more information on it over the next few days or a week or so. It's odd in a way, because we were getting asked this a lot, you know, in the aftermath of Brexit finally happening, and everyone was kind of confidently saying, well, you know, all these European derived laws are all that. It's UK law, so it's not going to just disappear unless they actually do something about it, and they probably won't. And then it turns out they actually did. So with one sweeping piece of legislation, but they did do it. So yeah, they're going to have to consciously bring it all back in if they want it. So be an interesting time over the next just over a year, I guess.
Yes, although the one caveat I would put is that no matter what you think of them, governments tend to want to be re-elected, and so they've got to, on occasion, keep the people happy. So I don't think we'll be saying goodbye to paid holiday. I would be very surprised if they did that, but we'll see. They might reduce the amount of paid holiday to make us more productive, you know, now that growth is the buzzword. Who knows? We'll have to wait and see.
And we are recording this session, so I'm not going to offer any comments on whether this government will get re-elected. I'll just leave it at that. Does anyone have any questions then on what we've been discussing today on unfair dismissal generally, or on anything else at all that they want to get off the chest or share with us today? Bearing in mind we are recording, so be comfortable with what you're sharing. Simon's got his hand up.
Thank you very much, Gareth and Julie. I have a situation where I've got a member of staff who has done, there's evidence of misconduct, and I'm going through a process. My problem is trying to judge whether it's just misconduct or gross misconduct, which would result in dismissal. But my question is there any benefit in showing the employee that there is the evidence of misconduct and inviting them to resign? By resigning, they maintain their dignity, and it doesn't get sort of publicised across the company that they've been dismissed.
The danger sometimes with that is that the employee could later rely on it to say they'd obviously made their mind up before the whole process had been conducted fully, and therefore it wasn't a fair process, because they were basically hinting, even though you're doing it benevolently and generously in their interests, they could turn it around on you and say, well, they basically told me to go before I was pushed, because and they hadn't heard everything that I had to say at that point, and therefore that was unfair. So that's the danger, and I suppose therefore it depends very much at which stage in the process you do it. You know, there is an argument to say you could do it right at the end, to say it looks like it doesn't look good for you, but it is just a very dangerous, because until you give that decision, really, you can't preempt it, and so I would tend to avoid that.
Yeah,
unless it's a very good reason. I mean, what you could agree is that any reference won't mention that, and you'll give a very standard reference just to say this person worked here as of this from this date to this date, and therefore you're not casting aspersions on their character, just keeping that blank. I think that's where I would go if you're trying to be kind.
Yeah. I think I would, just following up on that, I think it's not my preferred approach by any means. I know some people that do. Well, I have known examples of it being done, and people getting away with it, for want of a better phrase, and it being fine. But for all the reasons Julie said, it's not a preferred approach for me. All I just wanted to add to it really was, I suppose, two additional things. If you set about your process and the employee comes to you and asks to resign or offers their resignation, then so be it. And often that will happen, and there's no need to carry on with the disciplinary process. And often that's then going to make it very difficult for the employee later down the line to make any argument against that, to say that the employee did anything wrong, because clearly they jumped because they thought they were going to be dismissed, but actually we hadn't said that would happen. We were following a fair process. So certainly if the employee offers their resignation, then there's nothing to stop you accepting it. The other way of more legitimately offering, not so much offering an opportunity to resign, but offering an alternative, is under what's known as a protected conversation. So that is a legal mechanism that's protected, where you can say, and again, you've still got to choose your words carefully, exactly as Julie's described, but that is a legal mechanism to say, basically having an off-the-record chat and saying, here's where we stand, here's the process that we're going through. One outcome may be dismissal, so therefore an alternative is that we come to an arrangement. Now, sometimes that might involve a payoff, or a payoff. An employer might be reluctant to do that if they think they've got a strong case anyway. They're not going to want to pay off someone who's behaved really badly. But sometimes it can be something as simple as, one outcome could be dismissal without notice, but we would honour your notice if we reach a mutual agreement for you to leave, and things like that. So it needn't necessarily cost a lot more money depending on the circumstances. We would always recommend in that context that you have that agreement, if it is breached, secured under either a formal settlement agreement or via ACAS and the use of a Cut 3. But that's the safer option of doing that, albeit is a bit more formal, might cost you a little bit more money, but is a much safer process. And the reason it's a protected conversation is that then can't be referred to in an unfair dismissal case. So an employee couldn't say to a judge, well, look, they made me this offer, so they were bound to dismiss me. The judge can't hear that. It's a legitimate way of resolving a workplace dispute. That's all I've had there.
Thank you very much.
Any other questions or comments or?
No.
Great.
Okay, well.
Stunned silence.
Yeah. We like that. Well, if anything does come to mind, if anything specific you prefer to chat offline, you know where we are at all times. Drop us a line. Happy to discuss any situations that you might have.
Thank you both very much.
Thank you. Thanks so much. Thanks, everyone.
Thank you. Take care.
Thank you.
Bye.
Bye.
Thanks.
Bye.